Good evening, morning, afternoon, whenever you are watching this. Not legal advice. Please like, subscribe, share, comment, kick, whatever. Hi, Mr. StreamYard. Again, my most devoted fan. Born Free Films, John, the 1-1, Susan, Troy, Gator Boy, Market Watcher, US 1 Tahoe, Renee, Pat. That's all I see at this point in time. At least I could read. So far, I could read them. If you notice, I kind of tilt over. Anyway, hope everybody is well. So this is kind of part 2 of the last episode of the live stream that we did, where I talked about 2 of my favorite people, being the receiver and the receiver's counsel. I think what I did is I did the last one, and then I said I'd kind of wait 72 hours to see what happened. So it's been 72 hours. So I figured, I talked about a bunch of stuff. So, and there was a whole pile of stuff. So I figured I could pick a few items and kind of clarify some things or make some things. And then something else came up and I could talk about that too. It'd be kind of a different take. Before I start, by the way, before I really start, nothing I say here, and I know this may sound like really stupid, and a lot of things I might say might sound really stupid, but I still believe there's a very good chance that this deal closes. I just believe that if it doesn't close, it won't be the fault of, for example, AIversity. I think it will be the responsibility of the receiver and the receiver's counsel. I see that, but I'm optimistic going forward, but I'll tell you kind of how I see it in more detail kind of when we get into this. Before I start, I see some people, they must stay for like 42 seconds. And as soon as I tell these stupid jokes, they're gone. So to those people, I welcome you and have a great day and be well. Don't drive too fast. Hard work pays off in the future, but laziness pays off right now. And I'm good at that, by the way. Light travels faster than sound. That's why some people appear bright until you hear them speak. Obviously, even though I'm a lawyer, I don't really, or maybe surprisingly, I don't know, obviously or surprising, I don't have a lot of rules, but I am so clumsy in my car and spill so often that I only permit baby-sized cups to enter my car. Hard and fast rule. And last and not least, what's the difference between a lawyer and a trampoline? You should always take off your boots before you jump on a trampoline. Anyway, hope everybody is well. So I was going to talk about 3 things, which I will talk about. The 3 things I'm going to talk about are the audit. I'm going to talk about Astra, and I'm going to talk about double payments, and we'll get into some detail about that. Now, remember, this is, certainly not financial advice, not legal advice. It's not advice about landscaping most of the time. It's certainly not trading advice. So I never trade this stuff. I have shares, but I am certainly not going to trade them. One, I can't trade them. That's number one. Number two, even if I could trade them, until they're tradable for everybody, I don't think that would be right for me to trade them. So I won't. I will not be trading them until everybody else can. So I don't give any information, no recommendations, no whatever about trading, because I'm not involved with that. So you're on your own there, judge accordingly. So the 3 topics, I mentioned I was going to talk about the audit, Astra, and double payment. And before I get there, I'm going to fill in the blank, and then I'm going to talk about what somebody else said, and then we'll go into those 3 topics. So last time we talked about, I had a bunch of concerns because I was concerned about the Nintendo deposition. If it was a show, I didn't trust it. And then I was starting to write an email. And during the email, I get an order that's filed after the close of business, and it releases funds to David Reichman to be used for attorney's fees against the estate. and then I complete like a cover email to an email I had already written, but I held. So I talked about that, and then I talked about the letter that was sent before that event and how there were inconsistencies between what happened and between what even the receiver had. And by the way, I have nothing against. I will go into that in a second. I have nothing against anybody personally. My job is to call it as I see it and call out things and a couple other things, and I'll talk to you about that in a second. But if you recall, a couple days, 3 days before this, the receiver had apparently contacted certain people. I don't know why the receiver is reaching out to certain people, because, at one point in time, I think he said that it would only be by report or 8F, but apparently they're reaching out to some people and not others. And apparently, more than apparently, because this is all based upon what people tell me, so I don't really know much, because I don't have a lot of, other than my dealings in court, et cetera, or my interactions with everybody, everything else is what they tell me. And so I don't really know firsthand, but somebody told me that like they had an interaction with the receiver, and I don't know if this is true. They had an interaction with the receiver, and the receiver said, "Don't tell anybody about the interaction." So I don't know about that, and that doesn't really change. And I don't know if it's true also, because it wasn't me, but that was interesting that somebody would volunteer that. Maybe they didn't like the receiver, and maybe maybe it was a false statement, but that stuff catches my attention. So we went through that, and then I said I was going to wait 72 hours to decide what went on. And I thought about it a little bit, and I know I talked about at least two of these items in that discussion, but I really didn't kind of talk about it what I really thought after thinking about it more. That was in particular about Astra and the double payment. The audit was something we didn't discuss, but I want to discuss tonight. So the two things that kind of struck me again was in that letter that was sent on the 12th, like 3 days before the $20,000 was released to David Reichman for legal fees to be used against the estate. He said in the letter, amongst other things, I'm just reading from his email, transparency remains a priority. And remember, my concern about that was it was done after hours without any consultation with anybody, privately, a private stipulation with everybody, filed with the court, order granted without us ever seeing it. So to me, not wholly transparent, which again causes me concern. And the second part was where he says, again, I'm reading from apparently what the receiver wrote, because it says it's from the receiver. Maybe it's not from the receiver. Maybe it's from somebody who's impersonating the receiver. I don't know. Maybe it's from Little JR. He might be doing it. And hello out there at Little JR, if you're out there anywhere. Anyway, as reflected in the receiver's interim reports, GTII has minimal assets and faces significant challenges that makes its future prospects uncertain. I thought that was a pretty damning statement in light of what happened afterwards. But then, consider the possibility that if it was just money to get things done, to finish up a writing, to complete the transaction, then so be it. I'd tolerate that if that got the shares back and whatever. And I think I put out alert, calling all cars to let us know what's going on. And as of today, I don't know anymore. I do not know any more about the reason, the rationale that they used for releasing those funds. There certainly hasn't been any kind of report as the receiver promised. There certainly hasn't been any 8K, as far as I know, as the receiver promised, for releasing additional monies after hours, whatever. So I don't know anything more. So is that a problem? None of this is a problem. If this deal goes forward and closes, everything will work out. Everything will work out. But the flip side's true also, and I don't really understand why people don't get that side. From this point, from going back from the end of 2023, at least me personally, and there's been a lot of others kind of following a path, haven't stopped. I don't see any reason why we would stop. So, and this is not meant as a threat or anything like that. During Reichman's time, when I was sending emails to Reichman directly, and I was nicely telling them, if you don't respond or if you don't take care of things, and there's words to this effect, that there will be consequences. I said it to them multiple times, and all those people, that's like, early 24. Look where we are today. Look where they are today. So I don't understand, my in my thought process is, if someone who's involved in this particular transaction, if they're engaged in shenanigans, whoever they are, if this deal doesn't get done, we were not going to be finished. And that's not me saying it. There's tons of shareholders I know that if they think they're getting screwed on top of getting screwed, that, they will look for potential avenues to pursue. I think that's just a true statement. So I'm hopeful and still hopeful that this deal get done. I know that there are, I don't know personally because I'm not involved directly in any negotiations, but I know negotiations are ongoing. And I do believe, by the way, if a deal is not done, it's not going to be the fault of AIversity. I believe it would be the fault, again, I'm repeating this because I feel this strongly. I think if this deal or something at the same exact time, I don't think there's any other deal that's pursuing going forward, as far as I know. If this deal doesn't work, it's not going to be the fault of anyone other than the receiver and the receiver's counsel, in my opinion. And I don't know all the facts. I haven't been there everywhere, but I've heard enough stuff that would make me come to that conclusion. Now, my conclusion could change, obviously, if I hear other sides, different evidence, whatever. But that's my thought. So I'm going with the open mind that a deal's going to get done. But if it doesn't get done, then we got to lay out the other side. And the other side is what concerns, what things happen that cause me concern. Because, if you just ignore this stuff, then you can get, we ignored, we being whoever. I started ignoring it in late 2023, not for long, but I ignored it too. But we ignored what the conduct that the receiver claims against Reichman, we ignored that. So you can't ignore stuff. If enough irregular stuff occurs, and there's probably something to be concerned about. So I'm the ongoing negotiations. Hope it's going to conclude. No explanation about the 20K, but hope it's going to conclude. And if it doesn't, let's look at things that's kind of concern me. Before I start, I wanted to make a quick explanation. Bill Ferrand has I guess a YouTube channel. Somebody asked me, and I took a brief peek at it, and he at some point in time, because of my attitude towards him, I was pretty strong about certain positions he was taking, and he lost trust in me. And then I don't know what happened, but now he believes that I have the shareholders' interest at heart. So that conclusion, I thank you for that conclusion. I haven't changed in the least, but let me explain kind of how I approach it and how I let things develop. So I kind of used this term before, and I believed in this, by the way, before Reagan used the term. But the way I approach anybody is I approach them as a good until proven otherwise. So I let the facts speak. And I know, and I think he mentioned about 9 to 12 months ago, imagine how long ago that is. I think I appeared on his channel right after the receiver was appointed. And let me give you a little backdrop. So I mentioned this a little bit in the last live stream. I have experience with receiverships with regard to real estate. And I mentioned most times the receivership is the receiver and his law firm, and they basically double bill, and they take all the money out of the receivership estate. That's basically my experience. But it's usually, again, where the receiver and the receiver's firm are together. Now, that's been my experience, and the same with trustees and bankruptcy. It's been my experience also. But I'm open to the fact that certain circumstances might be different. And in this case, the different circumstance was that the receiver was not a lawyer and it wasn't his law firm. And I thought, at least at that time, that there was less chance for abuse and maybe there was more independence that could be asserted by the receiver, as opposed to where the receiver and the law firm are strictly aligned. And at that point in time, just to be frank, again, I take the position that everybody, notwithstanding that. So my experience is, I'm not a big fan of receiverships, but if you have to have one, you got to have one. And there's sometimes they're required, but you got to watch these guys like a hawk, because I don't really think their interests are aligned necessarily with the interests of others. And when William asked me on, he said it was 9 months to 12 months ago, the receiver had not yet proven himself, because that's 9 or 12 months ago, certainly not by then. The receiver had not yet proven himself to be, in my opinion, unreliable. That's just my personal opinion. And if I didn't believe that, I'm not going to say it. And my concern was by him attacking the receiver at that earliest a stage, that it would poison other people and it would make the receiver's job more difficult. And I didn't want that to occur, because no matter what, I still want this deal to go forward, because whatever happens in this litigation, if the deal doesn't go forward, whatever, the only people who make out at that point in time is the receiver's counsel and maybe the receiver. So I don't care about all that nonsense little stuff. I want the deal to go. But I do not believe at that point in time, I didn't want to completely alienate the receiver. I wanted to see how he would perform, again, because he wasn't a typical receiver, because he wasn't the attorney for the law firm that was representing the receiver. And I had no past experience with him, no business dealings, whatever. That wasn't the person I chose. I had no particular involvement in the choice of him. It just was presented as such. So when I reacted to William, I was trying to prevent the receiver to get alienated from like the day one. So at least we get a fair shake and get a chance to watch how it plays out. Now, time has passed, and I think enough things have occurred to raise questions and issues about certain things that have gone on, and I've done that, and I intend to do that, and will continue to do that. But again, I let it play out. I gave it was the same thing, by the way, with the receiver's counsel. I'll give you a fair shot. And somebody posted, by the way, I think it was Mr. Ben Palmer. Thank you, Mr. Ben Palmer, for your, it was a tweet on X. He was asking about, basically, he was inquiring or suggesting that the receiver came to me and said, listen, here's X, Y, and Z. Keep it to yourself until this comes public. Okay, fine. As long as it wasn't like he was going to screw the shareholders, why wouldn't I keep those things confidential? And I approach these people that way, but that was not something they were interested in. So my experience with receivers has not been great, but I gave this receiver a chance. And again, if the deal gets done, then the deal gets done. And notwithstanding whatever I claim or are concerned about, it's kind of irrelevant. So right now, I'm still giving the space a little bit of air to see what happens over the next couple days. And when I say that, it's usually not, I'm just not making something up out of thin air. There's usually a reason why I would say that. So I'm going to let it breathe for a couple more days and see what might pop out of here and see what might happen before talking about other important things. Everybody else, by the way, you could do whatever you think is the right thing to do. You're entitled to make any choice you deem you deem prudent. My thinking is, and I could be wrong, my thinking is that I can wait a couple more days because I don't want to cause any additional harm to the potentiality of a deal going forward. Although, if I was the receiver, in light of kind of the rigmarole at this point in time, if I was the receiver and a deal doesn't get done, I would be concerned if I were the receiver myself. Because I would have heard a lot of people very dissatisfied. There might be things that that shareholders might not have liked that have occurred. So, but the flip side's true also. Notwithstanding whatever happens, if the deal gets done, then most likely, it really doesn't make a difference what the receiver did or did not do, or his counsel did or did not do, to a large extent. So I'm going to let it play out. In the meantime, I got to point out stuff as I see it, so that if it doesn't go as we think, we're kind of lining up things as we go so we can make a case. So that's kind of the other side. So this is stuff that catches my attention, that I think was really concerning, besides what I mentioned before. So I'm just going to go bang, bang, bang on these items. Audit. We heard about the audit. I don't know. And maybe I'm wrong. Maybe I'm incorrect. The impression I got from all those reports and representations was, well, one, that this report has been ongoing for months. I think they changed auditors more than once. I know again, because I could be wrong, but my impression was that they were just waiting to get the guys to sign off, and that took another extended period. And then when those guys signed off, then they said, apparently, and I don't know if it was the receiver or the receiver's counsel. I don't know if you could tell one from the other, honestly. I don't know I don't know, for example, I don't know if the receiver makes any decisions or completely abrogates his responsibility to his counsel and lets his counsel make all decisions. I do not know. I do not know also whether the receiver, I don't know, by the way. So I'm just throwing these out, things that pop in my head. I don't know if the receiver has any relationships with any other shareholders that impact his decision making. What concerned me was, I was thinking about this recently. It wasn't part of the topics, but I'm going to throw it out here. This is a claim process. The receiver makes the decisions on the claim process. The receiver's counsel does also. Eventually, the judge signs off. But what if the receiver makes some justification for permitting some claim because he has some deal with some other shareholder? Could that happen? I don't know, but that's something that popped in my head because of the way things have gone to this point in time. Again, I don't have any great warm and fuzzy feeling that the receiver has any particular interest at all in the shareholders. My interest is in that, to the extent that he can facilitate a transaction to get this stock trading again, the company moving, and we all can go ahead and go on with our lives. That's what I see. So we got that, which is, an interesting thing. So we have the audit represented for months. And I was thinking, I kept on asking the receiver's counsel multiple times to ask about the status, the timing, whatever. He kept on saying no, and he said to the effect that if you ask, it might slow it down and they might get uncomfortable. And I thought to myself, under these circumstances, dealing with who we dealt with throughout. So we started off with the Reichman clan and moved through, management and family. And now I have concerns about other people. So should we be really taking these people on face value? Why? It makes no sense to me. Why? 0 sense to me. And zero. I don't know how much I could say. 0 sense to me that they have not provided any evidence that there is an ongoing audit that is going to completion. And my concern is the statement about not having enough money. He said there, they don't have enough money. How are they going to complete the audit? I don't understand how you would do that. And could you, and arguably say that there's an ongoing audit, and you could, at the same time, could you be telling the auditors just hang on. Don't finish it until we got the money. I don't know. I would certainly like some kind of representation from the auditor that there actually is an ongoing audit to completion, not some vague statement, because there's been no clarity as to that. Again, the impression I got was it was bang, bang, and ready to go. Then all of a sudden, when pressed, the receiver's counsel doesn't want to bother the auditor. And that's enough time has passed. Maybe innocent, but every action like that just raises my suspicions further. And if it's a case, again, maybe nothing's going on. Absolutely nothing. If this turns out to be a scam, then there probably is no audit going on, right? So you never can tell. Trust and verify. So I've asked politely multiple times to get some confirmation about whatever's going on. So, Mr. Receiver, I call you out and ask you to present evidence that there is an ongoing audit that is going towards completion. I'd like to know a date or a time frame for that. There is no reason not for disclosing it. When you don't disclose it and nothing moves, and you at the same time you assert there's a monetary problem, how are you not supposed to be concerned about the audit that's been dragging on for months? Again, just the bottom line. I have no reason to suspect it's not a legitimate audit. I have no reason to suspect that. But if this turns out to be a scam, it wouldn't be a legitimate audit. And we know already that from this company. Just think about it. So you're managing this company. This company had the worst auditors in the history of auditing that basically got banned by the SEC. Somehow now you're claiming there's a new audit going on, but you're not willing to provide any evidence of when it's going to be completed, if it will be completed, or if it's ongoing. And we're supposed to trust you. Okay. No thanks. Call me a skeptic. No thanks. So even if it's not me, even if it's a selective notice, again, improper, by the way, but even if it's selective notice to some shareholder by sticking a fortune cookie underneath their door with a little message about this, tell somebody. Show us so we can have a little peace. Because my understanding is until that audit is complete, we can't be trading. So my understanding was it was a prerequisite to trading. And the answers that have been provided by counsel for the receiver and the receiver to date have been inept and inadequate. And if you were suspicious, you'd wonder what was going on in the background. Again, if this deal closes, transaction goes, I'm happy as a clam. If it doesn't, we're just kind of talking about evidence on the other side. It also should teach these people a lesson on how to treat other people. They could have been clear. They didn't have to be dismissive. They didn't have to treat us like garbage, really. I mean, those guys are operating. This is, again, my own opinion. Those guys seem to me to be operating in their own personal best interest without regard. We just seem to be like a prop. They use us as a prop. They go do their own things. Attorneys go through a bunch of tasks, generate fees. The receiver generates money, I guess, and collects money. And I'll talk about that in a second. So I don't know about the audit, causes me concern. Maybe it's nothing, but these guys should know. Again, a lot of this stuff, these guys should be smarter and know better and whatever. Second one, this one really, I talked about it. Astra Energy, that lawsuit, I brought it up. And, afterwards I thought about it, how ridiculous that was, but then it made sense. It actually made sense. So my concern, so they filed a lawsuit, I think the end of July against Astra Energy. It's on like a $250,000 debt that's owed apparently to GTII. That's $250,000, which is relatively small potatoes in this grand scheme of things. So that means they paid counsel, the receiver's counsel, to initiate a lawsuit, probably thousands of dollars in legal fees, to go out and chase these guys. Perhaps they will be successful in recovering money. So again, they said they were low on money and whatever. And then I was thinking about it. So why would they do this as opposed to like filing an action against Justine or doing a real deposition against David? Why do that? And I was thinking, sounds like easy money. Easy money. They must think it's easy money. Again, this is like an example. Has nothing to do with the shareholders, has nothing to do with the conclusion of the deal, has nothing to do with anything other than the fact that if they were successful in this litigation to get $250,000, the attorneys for the auditors would get whatever monies they generate in the litigation. The receiver would get 10%. I hear something. It's in my pocket. The receiver would get 10. Sorry about that. The receiver would get 10% of that 250. So the receiver would get a quick 25K. And then there would be a pot of 200 and some thousand available for the lawyers to use to do something else that really didn't assist shareholders and was just kind of like doing activities to pay for doing activities without having an end in the best interest of shareholders. There's no other way you can construe that Astra lawsuit. It makes no sense. Why spend an abundant sum of money benefiting only, really one party, and not go against the ones who are with multi-million-dollar claims? Made no sense. So when I thought about the Astra Energy, it made me think much more that the interests of the receiver and the interests of the receiver's counsel, this is just my opinion, I could be wrong, are solely personal, individual, and without regard to us. And as such, that's my stance from this point and forward. So I don't take anything at face value that the receiver or his counsel says from this point in time. And I certainly don't believe it's in our best interest. Again, doesn't stop us from getting a deal done. Doesn't stop the fact, as I said, that if a transaction happens, I care less in the end if I'm right. But if they close a deal, then great. This only is relevant if no deal is closed. And again, when I go through these, and I get, again, I waited 3 days, I gave them an opportunity to contact me, nothing. And again, they've reached out to other people, so it's not like they can't. And the fact they would reach out to other people and tell them not to share the information with other shareholders, I just don't think that's appropriate behavior if it's true. So, and again, I have no reason I take everybody at face value. So if somebody comes to me and they tell me something, I assume what they tell me is true, unless I find out otherwise. And if someone tells me otherwise, that's great. I'll accept that too. But I'm flexible in terms of not married to either position. But somebody told me that, and I found that, again, inappropriate, probably worse than inappropriate. But again, if a deal gets done, then I care less. It's only if a deal doesn't get done. And these like indications about the audit and the Astra Energy, like lining, are they lining their own pockets only? It sounds like to me. Sounds like. But I'm a skeptical, cynic, whatever. Last point is the double payment. So this is what I thought. And again, I mentioned a little bit in the live stream, but now I'm going to kind of put it in a different context. So during my attempts to make nice with the attorney for the receiver, I was bitching at him because the receiver hadn't filed a report in who knows how long, and we were, in the dark. And I think I reached out to him numerous times. And then he told me that he personally was preparing the report. It was over 40 pages. And whatever. I let the report go out, and I read it over. It was very detailed. And then I thought, and this is what occurred to me afterwards. So what is the receiver getting paid for? Receiver's job is to, one, to keep us apprised in some fashion, keep the court apprised, and to collect money, run the business, sue whoever is appropriate to sue, etc. Part of his job is to write the reports and communicate with shareholders. So based upon what the attorney, I think there's emails that would reflect that. I haven't looked, but I know we talked about it a bunch, and I assume I put it in some kind of email to him also. But my guess is that the attorneys got paid for that task that the receiver should have undertaken, and that task might have been in the tens of thousands of dollars. I've asked the receiver for copies of the invoices. To this point in time, he's refused. And and ultimately, and this is not meant to be threatening in any way, but ultimately, if there's a issue that needs to be litigated in any litigation, those kind of documents would be produced eventually. So when you ask for certain documents, you can redact certain portions. When you ask for certain documents and somebody refuses to turn them over, it makes you believe there's a reason they're not turning them over. Part of that, my belief, is that the billing for these reports must be gargantuan. And when he's talking about, and this is all speculation on my part, by the way, so I could be completely wrong, just making up stuff. I'm not making it up, but it could be like, I don't know, just speculating. But when he said in that report on the 12th, we basically got no money. And I'm thinking, where do they spend all this legal stuff? What have they done? This is not a case where they've done like 20 depositions. There's been 50 court appearances. They've been writing reports that the receiver should have written. So my thought on that was, if that's true, other than the one that I was told about by the attorney directly, that was clear because he told me. I presumed, and he might have indicated that, but I don't remember as I'm sitting here today, that he was intimately involved in the writing of prior ones also. That's not his task. We shouldn't be charged for that, and the receiver shouldn't be paid for that. So we shouldn't have double charges, double payments. Again, as I've said multiple times, I don't care what the outcome is, but I don't want to be charged for work that wasn't performed, or be double charged for work that should be only charged once, or charged at a higher rate for work that should have been done solely by the receiver. So that just happens to be another particular point. So that's all I wanted to talk about. Those three things: the audit, where is it? Astra, who benefits there? What's the logic? Why not pursue something that benefits the estate? And the double billing and double payment possibility, who knows? But are we getting charged by the law firm for work that the receiver should be doing? And is the receiver being paid for work that the law firm is doing? I mean, these are questions that come up. And, if we ever got to the point where things fell out and everybody tried to get home, these are kind of the issues that we'd have to discuss. So I figure, as we go through it, we can keep a record of all these things. In the end, hopefully we just discard it in the trash can as as an exercise during a case. Otherwise, it might be relevant. So now you're all witnesses in some way, and you kind of understand the way I think in part. And I'm just going to let it play out for the next couple of days. We'll see what goes on. Maybe we'll get an explanation about that 20K. Again, I would hope, and I'd welcome the fact if they told us the 20K was to provide counsel for Reichman so he could complete a settlement agreement to give back all his shares, and everybody else can give back all their shares, and that's the end of the case. Yeah, as I said on a tweet or an X, whatever you call it, if that's the case, I'm all for that. Notwithstanding, giving him a 20K and he deserves zero, and in my opinion, he's a complete scumbag, along with everybody else associated with whatever he did, who approved that. No, I have no regard for him. No regard. I wouldn't give him a dime, honestly. But if it's to get the case over and we get the transaction done, then I'm all for it. If it's just to dick around, if it's to get money for him to use it as a defense, but it doesn't resolve anything beyond being bad strategy, as I kind of like referenced in mine, it would really piss me off if that's the case. The only thing that would make sense to me is that if that money is going to be used to finish this transaction. If it's not, that's a complete misread of the room. Again, in my mind, it would be like somebody trying to justify giving Bernie Madoff some money to defend himself against his victims. I mean, where would you have to come from to not get that that's inappropriate? So we'll see. Again, if it's to help us to finish this, I'm all for it. So kind of talked about my strategy, why I approached the receiver as I did at first, believing, giving him a fair shot, not wanting to antagonize him, so I could at least go in with a fair position. So he couldn't accuse me of torturing him from day one. You can say at this point in time, we're not particularly friendly, obviously, but I gave him a fair chance. And I didn't want to, at that time, I didn't want to cut out his legs and make it impossible. And again, a deal still may be heard. Then we talked about the audit and where it is and why it's not been finished and where's some kind of certification about it being completed and about the illogic about why they didn't reach out and find out a timing of it. Then we talk about Astra and whose pockets that would line, a portion to the receiver, a portion to already burning fees on that action, I would guess. I'm guessing. The only other thing is they might have it on a contingency and they would get a cut of that, which I guess would be even worse. I don't know, because they would get a cut of it, then they would have a pot of money and they would bill on that. I don't really trust the services of the receiver's counsel, as I told you. So I don't know. And then last but not least was the double payment, the double that the receiver should be preparing reports. I know at least one the receiver's counsel did. I don't know if we're getting charged for both. Is the receiver doing things that he should be paid for? Is the receiver's counsel overcharging us for the money? There's been a refusal to turn over the invoices, and we'll just keep on following this. So, as time passes and I get an opportunity to update you, I shall. And if you have questions when you take a look at this or when you see me on Twitter or X, please reach out. But that's the update as of today. And I know negotiations are still ongoing. So that's kind of fresh update. That's my understanding, that things are still ongoing. No reason to suspect otherwise. And again, I'm hopeful that things will go positively and we will get this done. But if we don't, we're putting together our kind of our P's and Q's, and everybody should be aware of that who might be, to the extent, I should put this out, to the extent that anybody's involved in, and again, I'm not accusing anybody because I'm not aware of it. I'm only aware of when I'm talking about raising questions, that's all it is, raising questions. I would like answers. I would love somebody to have answers. But beyond that, if anybody I'm not speaking to, it was engaged in shenanigans with regard to GTII, if you come forward and admit to it, usually the results are going to be much more minor. All of us just wanted to trade. We just want information. So if you have information and you want to help out, feel free to contact any shareholder. Feel free to reach out to me. And we're not a vindictive crew. We just want this stupid thing to trade so we can make our money back. At least that's my feel for the shareholder base. So anyway, anybody out there who, might want to speak, feel free, reach out. We'll protect you. Anyway, to all you out there, be well, take care. If anybody has anything interesting to pass on, feel free to pass it on to me. When I have some new information, I'll let you know. Again, I'm optimistic about the deal, so I'm just going to wait for it to go forward. And all this other stuff is probably just based upon somebody who really doesn't know exactly what they're doing or how to do it or anything like that. And it's either innocuous or it's not. And we will stay on top of it so we won't let anybody get a free pass. Anyway, thanks again, everybody. Take care. Be well. Have a good night. And that's it. That's all, folks.